Surfs Up on TikTok asked if you can designate a P.O. box as a place where a tenant can send payment instead of a residential address. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, under the Code of Civil Procedure, Section 1161, Subdivision 2, that governs non-payment of rent cases in California, a landlord can designate a post office box address where tenants may make rent payments. However, landlords should be aware that there's a nasty evidence presumption that the tenant can take advantage of in the Code of Civil Procedure. Particularly, it relates to P.O. boxes and other addresses where payment cannot be made in person. That the law basically says for non-payment rent cases, then if the tenant can show proof of payment, like a certificate of mailing or certified mailing of the payment, then it's conclusively presumed that as of the date of mailing on the tenant's payment, that's when the landlord received it. So there's a consequence for using a P.O. box. I generally don't recommend necessarily that a landlord use a P.O. box for this reason, because I've had several cases where tenant or landlord has a P.O. box, tenant mails the payment, then in 3 business days, right, or 3 court days, excluding weekends and holidays, landlord doesn't receive the payment, right? They tell me, hey, Rob, go file the eviction. And then on the 4th day after we file the eviction, guess what appears? Rental payment in the mail, basically. And that's because sometimes the postal service, things get delayed and so forth like that in the mail. So that's the consequence of having a P.O. box as a form of payment address. Okay, generally prefer that the tenant make payments in person. That way, if there's ever a dispute, you or your authorized agent who you directed that payments be made to can testify in court that tenant made no efforts to pay rent. Okay. Now, for purposes of Civil Code Section 1962, a P.O. box would not be sufficient to give to a tenant for purposes of disclosing where an owner or an authorized agent can be served service of process, because that address has to be a place where you actually can be found and be given legal documents, that type of deal in person. So recommendation probably for a situation like that, you can have a P.O. box for your payment address, but you're going to have to disclose some location where you can be personally served, or your property manager or someone authorized to manage the property on the landlord's behalf. They have to have a place where that they can be served personally. So a landlord, in theory, could, if you're a personal landlord, you can designate your place of business or your employment place where you can be served if you didn't want to give a residence address. Many landlords that self-manage will just disclose their residential address, but I understand people don't want to do that. So those are some solutions. Those are some things you should be aware about. Okay, folks, if you're dealing with a non-payment of rent situation with your tenant or another tenant problem and you're in the Northern California area, feel free to reach out. You might be able to help out. Put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.